Welcome to another edition of the Manufacturing News Network. My name is Jason Moss, and I'm the CEO of the Georgia Manufacturing Alliance, and we're really excited to have you guys as part of this educational series that is sponsored by our friends at Taylor English. Today, we've got some great information that we'll be going over, and Russ Dunlap is our liaison for Taylor English. And with that, what I'm going to do is I'm going to turn it over to Russ and take it from here. Russ.
All right, sure. And I am not going to talk very long because I'll introduce our moderator for today, and he can introduce all the panelists. But my name is Russ Dunlap. I am kind of a contact person for GMA for Taylor English. I am a patent attorney. I do IP work for my clients. A lot of them are manufacturers. But we are a general practice firm. We have attorneys across the board. Today, we are featuring some very knowledgeable labor and employment attorneys to talk about some of what we can expect with the new administration for union laws and union organizing and those things. We also do, we're a general practice firm that does also taxes, business, litigation, corporate formation, bankruptcy, all those different things. So if you do have a legal question and you send it my way, I almost guarantee I know an attorney that can help you at the firm. And that's what we pride ourselves on, is our collaboration with each other and our very wide knowledge base. But with that, I'm going to go ahead and hand this over to Raanon Gal, one of the partners in our labor and employment group, and he will introduce the panelists. Raanon.
Thanks, Russ. Good morning, everyone. Yeah, we do have a great panel. Again, as Russ said, my name is Raanon, and I'm the co-chair of the employment group at Taylor English, and we have Peter Spanos, Michael MacHarg, and Joe Bryan, who specialize in traditional labor and union avoidance, and that's really what today is about. And as Russ alluded to, we had an election. We have the Biden administration, which is going to be a lot more employee friendly. And for the first time in a long time, given the administration and the Senate makeup, as well as the House makeup, there's some real chance for union proponents and employee-friendly groups to pass legislation that can really change the current landscape as it comes to traditional labor and unions. So, that's what we're really here to talk to you guys about. This is a great group to talk with you about this issue, because the manufacturing industry is really usually a big target of the union. So today is especially timely. So I'd like to get started and talk to our great panel. And I guess, Peter, one of the big things that are out there that I've at least heard of, and I think a lot of employment attorneys and people who are a little bit worried about how far the landscape's going to shift on employment laws is this ProAct. And can you explain kind of what that is?
I'd be glad to. And good morning, everyone. The ProAct, the full name of the ProAct is the Protecting Right to Organize Act. At the time of the election, the federal election last year, the ProAct had already been passed by the House of Representatives, but was stalled in the Senate. It has had a long history with the Democratic Party, but more importantly, to understand what the ProAct is all about, we look to candidate Biden's declarations when he was running for president. Not only did President Biden at the time indicate that he wanted to be the most pro-union president in history, that's a direct quote, but also both in his campaign speeches and his website, he advocated strongly for the passage of the ProAct if he would be elected president, because it's his view that the government should not only defend workers' rights, which of course is already done under the National Labor Relations Act, as you know, but also the federal government should actually promote and enhance the ability of unions to organize workers. So the ProAct is a collection of what could really fairly be termed a wish list of organized labor. It contains many things that organized labor advocated or sought over quite a long period of recent history, but had never been able, except for some during the Obama administration briefly, had never been able to bring into law. The focus of the ProAct is primarily, but not exclusively, on the National Labor Relations Act and the National Labor Relations laws, and therefore would affect not only primarily how the National Labor Relations Board functions, but would also affect those rights of workers, even in non-unionized companies, that are guaranteed by the National Labor Relations Act. And it includes some things that are outside traditional labor law too. After the election, the ProAct was passed within a few days of the inauguration in the House. It's currently in the Senate Bill 420, and has 44 supporters, 44 co-sponsors. So the ProAct is the Democratic Party's centerpiece legislation for advancing the interests of union organizing in the workplace.
My understanding is that it's going to change really the dynamic when it comes to the collective bargaining process, union organizing, elections. With that said, Michael, how is it going to affect union organizing?
Okay, thank you, Raanon, and good morning, everybody. Thank you for having me and us. To directly answer that question, I think it's necessary to take a step back and think about where we are presently and what the current rules are. Currently, when a union tries to organize a facility, they need to get 30% of the cards, but most unions require a number that's at least double that, sometimes higher, 60 to 70% before they petition for an election. The ProAct will change this drastically. Many of the reasons are covered by Joe, so I don't want to step on his presentation. But what it will do in terms of the organizing itself, first of all, it seeks to codify what's become known as the ABC test from California, Massachusetts. And what that means essentially is that the independent contractor exception will be entirely eliminated from the National Labor Relations Act. I call this the politicians hate Uber part of the statute. They're going after one company in particular, and organized labor, the SEIU, has been after Ubers probably since the day they were formed, and the beatings they take in the media and from organized labor are relentless. The second thing that's going to change, and again, in terms of who's organized, is this changes the definition of supervisor, and that could be very important. Historically, employers use their frontline supervisors as the key people in preventing union organization. They are the lifeblood and mouthpiece of the organization. Currently, the National Labor Relations Act recognizes a 12-part test that's in the disjunctive. So if you perform any one of the 12 enumerated duties in the statute, you are considered a supervisor and not eligible to be represented by a union. This will change in a number of ways. First and foremost, the new rule would make supervisory duties be a majority of the time and no longer have the disjunctive test. In addition, it eliminates simply assigning work or responsibly directing employees. So two of the categories are eliminated. An employer would be very hamstrung during an organization without its supervisors because it wouldn't have a very meaningful way to communicate with its workforce. And a secondary way that they're seeking to hamstrung employers is presently an employer has a specifically enumerated right under the National Labor Relations Act to guarantee its right to free speech to its employees. This act eliminates the right of the employer to have meetings with its employees during any organizing. So the employer now doesn't have its supervisors as a mouthpiece and can't even bring its highest level executives in for meetings. It's no longer allowed to communicate with employees. Additionally, they're restricting employers' ability to receive advice regarding union avoidance. This was tried briefly during the Obama administration. The ProAct codifies it again. And what it would do to chill employer advice is it would make any payment to a law firm or consulting company or whomever a reportable act to the employees and for the world to see. So they would have to report all income or all expenses paid to a law firm in conjunction with any advice being given regarding union avoidance matters. This would have a very chilling effect on the lawyer-client relationship. Another thing that the ProAct does that will give a substantial advantage to unions is it will require that personal information of the employees be given to the union at the onset of any organizing. This would include home addresses, known cell phone numbers, email addresses, other contact information. This freaks employees out frequently. They think they have a right to be left alone in their own home, but this would be a very strong leg up for union organizing, as they would be able to contact each and every employee in their home or in their private space, cell phones, what have you. And obviously that gives them, halfway head start around the track. The last thing I think that's important with regards to organizing is this has been a controversy for at least 20 years now, but the question of whether or not the unions gain access to employers' electronic systems. And most of the flashpoint of this battle has been centered around email, and the pendulum has swung back and forth. Initially, they had no right to it. Then under Obama, they had a right. Then under Trump, it swung back, no right. The ProAct would codify the union and the employee's right to use the employer's systems, particularly email, although I hasten to point out that we're on Zoom. So if an employer has a Zoom account, presumably the union would be allowed to use it in off-duty times to organize. I always throw a word of caution. I know I have a minority opinion in the labor law world on this. I don't know that it's necessarily a bad thing if the unions want to use our email system. Just make sure you have an ironclad policy that allows you to look at their emails at all time. And if they want to send us the playbook with no way to know we're reading it, then that's their business. But for the most part, this is detrimental and burdensome on the employer, just giving more bothersome access to unions where it probably doesn't belong. And Raanon, those are the high points of the changes to organizing in the ProAct.
Thanks, Michael. One of the bigger things that I think freak employers out is when they get notified that there's a union representation election. And I know, like Michael said, the pendulum is swung, it swings back and forth depending on the administration, on people trying to, change the rules in their favor. So how is this going to potentially affect union representation elections? Is it going to stack the deck against employers and give unions, carte blanche to be able to get into to everyone's companies?
Yeah, you want me to respond to that, Raanon?
Yes.
All right. So first of all, thanks. And thanks, Jason and everyone for being here and having us here. It sure does, to answer your question, Raanon, it really attempts to put an anvil on the scale in favor of the unions when it comes to union elections and representation elections. This statute removes the employer from the process of determining how representation elections will be handled, how they'll be conducted, and leaves it up basically to the unions and to the NLRB. The union would still file a petition for an election, and then the NLRB would determine whether or not that unit is appropriate. Right now, we have a lot of say in what is an appropriate unit. Sometimes we're able to negotiate the scope of the unit, who gets to vote in the unit, in the election. We would lose that right. We would no longer have a voice in determining who gets to participate in the election. There are a couple of significant areas there that I think would be big changes for us. And some of these Michael mentioned briefly. One is the change in the definition of supervisor in this act. And where that's going to really matter for us when it comes to elections is team leaders, lead people, team leaders. Because sometimes we want them to be in the voting unit and to cast ballots. Sometimes we need them to communicate and to take the company's message. And they have, it depends on company to company, do it differently. Sometimes they have a great deal of authority, but not quite the independent judgment that someone in the position of true supervisor would have. But the changes to the definition of supervisor in this act almost make it certain that team leaders would be included in the voting unit. So we lose that. The other thing is, and I don't want to get into this too much because we could go on for days, but change in the definition of joint employers and how that will impact elections under, if this act were to become law as written today. Most manufacturers that I know have some temporary employees. And I think that's the biggest area where this would impact that. If the union seeks to include temps in the bargaining unit, then there's a much higher chance that the temps would be included now than has been the case in the past. And so it could tie the employer's hands there. The other thing is what most of us have heard of, if you've been around for long at all in this area, you've heard about micro units, where a union can petition for a very small unit out of a workforce, and the board will approve that. Typically now, the board would say that would be inappropriate. Say, just to give you an example, the machinist union comes in and they file a petition to have an election in a group of, in your machine shop. Common group, highly skilled employees. Sometimes they're even in their own area or own building. They have their own supervision. Their pay is usually a good bit higher than the rest of the workforce, and the union seeks to carve them out to represent only them. And it just so happens that the union has signed up 90% of them on union representation cards. This statute would make it almost certain that that could go forward, unless we could show, or unless someone could show, the board found that the rest of the employees in the facility, say all production and maintenance employees, had an overwhelming community of interest with those in the machine shop. So that's a big deal, and could give a union a foothold in a plant that they otherwise would not be able to get. Another thing that would change when it comes to elections is right now, if we're working with an employer on an election, we regularly have meetings and present information to employees in meetings that the employees are required to come to under most circumstances. Here, this statute prohibits that. We can no longer require employees, even if they're on the payroll, to come to the meeting. So the 24-hour, 25th-hour speeches that we typically have used right before the employees go in to vote would be no more. We could do a meeting, but you just can't require them to come in. The next thing is that the way the election is actually conducted. right now, or at least pre-pandemic, there was a strong bias in favor of having elections on site at the employer's premises during or very close to working hours. And the reason was very simple. The employees are there, they're more likely to vote. And the board wants employees to have the franchise to vote in these elections. That would change under this statute, and the union would get to select the type of balloting that it wants, whether it is on site still, or at some other location, or by certified mail, or even they're anticipating some other type of electronic means. So whole new ballgame when it comes to the way that elections are conducted. And we would have to, we're already planning to adjust our strategies to meet these new realities should it come to pass. So I think that sums it up.
Well, thanks, Joe. Yeah, they're really stacking the deck though.
Yes, exactly.
on that one. Circling back to you, Peter, how is the ProAct going to affect collective bargaining?
Raanon, it's important to recognize that not only does the Protecting the Right to Organize Act give unions new advantages in the organization and election process, but it also gives the unions additional advantages in the collective bargaining process, either in the case of employers that already have a union relationship or in a case of employers that are newly organized. So let's start with the newly organized. What are the changes there? Currently, there is a kind of balance between the employer side and the union side, in the sense that either side can at a certain point say, no, we've reached an impasse, we will make no further concessions. And then it becomes a matter of the economic circumstances of both parties. And that is a traditional feature of the National Labor Relations Act that goes all the way back to the original passage of the act. Under the ProAct, for companies that are newly organized, this procedure is dramatically changed, because not only under the ProAct does the employer have to bargain with the union within 10 days of the union's demand to do it after an election or other recognition of the union, but also if the bargaining goes on for 90 days without a contract being reached, either party can call for mandatory mediation. Now, currently, parties to collective bargaining agreements can call in, if both agree, they can call in the Federal Mediation and Conciliation Service, a federal agency established by the Act, and use those federal mediators to attempt to reach an agreement. But it, like all other mediations, it is a product of the parties' agreement to do so. Under the ProAct, either party can require mediation. So that is a step forward. And of course, it'd be most likely the union that would call for mediation after 90 days. But the ProAct goes further than that in tipping the balance in favor of the union's position in negotiations, because if the mandatory mediation fails to reach an agreement in another 60 days, then the Federal Mediation and Conciliation Service is required to refer the matter, the collective bargaining agreement negotiations, to a tripartite panel of arbitrators who actually decide what the agreement will be. One of the arbitrators is selected by the company, one is selected by the union, and those two select a third. This is what's sometimes known as baseball arbitration. It's a similar system in professional baseball. Those three arbitrators would then hear whatever evidence in a kind of an evidentiary hearing, not unlike a trial probably, would hear evidence about what the union thinks the wages, hours, and working conditions and benefits should be, and also what the employer does. And the panel can ask for information, which opens up the union's access to information about the employer beyond what currently they can do. Under current law, if the employer places an issue on the table as a defense to a union demand, then the employer has to provide information about that. But if the employer doesn't argue, for example, inability to pay or something like that, then the employer need not open its books and records to the union. But in this kind of hearing, the arbitrators can ask for that information. So at the end of this hearing, the arbitrators will decide a collective bargaining agreement. and impose it on the company for a period of at least 2 years. So you can see that for a first agreement, the employer faces a stiff hill if it wants to resist the union's demands. Now, with respect to ongoing relationships, many companies and unions have excellent ongoing relationships, very productive. A little bit will change there too, because of two other changes. First, at the end of a normal bargaining session, where you have a renewal agreement between the parties, if the employer and the union cannot reach agreement and reach an impasse where neither side is willing to compromise, the employer under current law then can put into effect its last offer to the union. This allows the employer to move ahead and to determine the wages and benefits and make what changes that it offered to the union that the union rejected. Under the ProAct, the employer would never be able to do that. The employer would have to continue the old contract during further negotiations. And this means that the employees will become more and more restless and unhappy as negotiations go on, thereby putting a lot of pressure, more on the employer side, I would say, than on the union, but putting on a lot of pressure for the parties to agree. In addition to that, the ProAct would revoke a more recently adopted part of labor law that allows an employer to withdraw recognition from the union, that is, not bargain with the union, if the employer has evidence, in other words, real evidence, that the union no longer is supported by a majority of the employees. Under today's law, as it exists with these recent changes, an employer can withdraw recognition and not bargain with a union that is no longer the majority representative. The ProAct would eliminate that thing. So as you can see, the ProAct grants advantages not only during organizing, but also during the collective bargaining process, even in situations where the union and the employer have been bargaining successfully for a period of time.
How about picketing and strikes, Michael? I mean, is that going to be affected too by the ProAct?
Absolutely, Raanon. If everything up till now was putting their thumb on the scale, this is probably taking a sledgehammer to the scale. As Peter was discussing, when negotiations reach that tender point at the end, it's time for the union to decide whether or not they're going to try and impose their will on the company. And the way that's done currently is through the use of a strike. And I taught law school for a number of years and always tried to explain to my students that whoever had that power going into the negotiations, if the union had the wherewithal to pull the employees out and they would go out, then the employer would probably have to give in. And if the union didn't have the type of employees that would hit the picket line, then the employer would probably dominate the negotiations. This takes that relative economic power and reduces the equation to meaningless. Currently, an employer is permitted to operate its business. The National Labor Relations Act was passed in 1935, and almost immediately in 1938, the Supreme Court found that employers could permanently replace strikers for the economic benefit of the country and for their operation of their business. The ProAct eliminates permanent replacements. So employers would no longer have the right to call people across the picket line. And as you can imagine, if people don't have the incentive of long-term employment, they're going to be dubious about crossing what could be a violent or difficult picket line and dealing with the reverberations of union retaliation for crossing said picket line. So that would be a big deal. Another thing that changes in the realm of strikes is presently the duration of strikes or the timing of strikes, how they're effectuated matters tremendously. A union is not permitted to strike on and off, 1 week on, 1 week off, 1 week on, 1 week off in an effort to disrupt operations. Nor are they allowed to take just one particular group out, say nurses from a hospital. It may not be optimal, but you get the picture. You're not allowed to take just one group out. I guess for manufacturing, you can't take out just the janitors. So now unions will be able to pick and choose who goes on strike. They could just pick key employees or key groups of employees. They could pick key employees one day and production employees the next day and another group the next day and quality control the next day and on and on and on ad infinitum. An employer would not be able to respond to that touch and go tactic that unions would have enormous leverage over the employer. And finally, the secondary activity sections of the current National Labor Relations Act, which prohibit picketing and boycotts against unaffected third parties, would be eliminated in its entirety. And so what this means, it probably would have its largest impact in the construction industry, where you can have union and non-union workers working side by side. And you have a gate for your non-union people and a separate gate for your union people. This does away with that recognition. And so if you're a manufacturer and say you sell to Walmart, unions would now lawfully be able to go out to Walmart, picket you there, picket Walmart, ask customers not to do business with Walmart because they do business with you. And of course, some employers are very, very sensitive to how that looks in the public eye, what their public image is. And unions being able to lead unlimited boycotts would give them an overwhelming advantage at the bargaining table and just in the day-to-day management of the workplace. So this is really the change to the nation's strike law. It would be one of the more heavy-handed changes, and employers would lose most, if not all, of their latitude in steering the ship on their own business.
Thanks, Michael. I also, understand that, this new law is going to change the enforcement of these federal laws as well. Joe, what sort of changes are in store for the penalties that can be handed down for violations of the law?
Right. It's a complete overhaul, really. I mean, they retain this law would retain what is already there, but add much more to it. And this has been an area where unions and their advocates have been seeking change for decades. They've always complained that the teeth in the National Labor Relations Act are not adequate to prohibit violations by employers. So the first thing that I'll mention is with an individual discharge, for example, an employee is fired during the course of a union organizing campaign, claims that he was fired because of his support or activities on behalf of the union. So right now we would be able to have a hearing. If the the National Labor Relations Board finds that the employee was fired because of his union activity, that's unlawful. The remedy then would be to order reinstatement of the employee with back pay plus interest, and the employer would have to post a notice that says, these are your rights under the National Labor Relations Act. We violated the act in this regard. We won't do it anymore. And that's it. In the vast majority of cases. The ProAct would change all of that. It still has back pay, reinstatement, and the notice posting, but now we would not be able to take a deduction from the back pay for anything the employees earned in the meantime. So any interim earnings, as we call it, would not be deducted from the back pay the employee is entitled to recover. He might be entitled to front pay if he's not reinstated. He would also be entitled to recover consequential damages, and that's not really defined in the law, but there are definitions that would probably be borrowed by the board and the courts to determine what that is. And so damages that flow from the fact that the employee was discharged. For example, if he loses his health benefits because he's no longer employed. Well, what are the damages associated with that? And you can see how it doesn't take too much imagination to see how that could mount up very, very quickly. Then the statute would impose liquidated damages as a penalty. So double. The liquidated damages in this case are 2 times all of the other damages that are found to be appropriate as a remedy in this case. And then civil penalties, where there is essentially a fine for violating the act of up to $50,000 per violation. And then if there's been a similar violation within the prior 5 years, that could be doubled to $100,000 penalty per violation. So significantly different penalties, damages, and remedies under this act. Another thing that's really significant here is that it changes the forum that employees can use to seek recourse for what they claim are violations under the act. Right now, employees' unions file charges, unfair labor practice charges, with the National Labor Relations Board. The board investigates, makes a decision, and we go through the NLRB process and only get to a court if we go to a U.S. Court of Appeals to seek review of a National Labor Relations Board decision. This statute gives employees the right to file a lawsuit in federal court or to go to federal court after 60 days after filing a charge with the NLRB if a complaint has not been issued. And in that case, they would have a federal judge reviewing the matter, would be able to be represented by independent counsel as they are now, but it's rare. And so a whole different means of enforcing individual or group rights under the Act. And the final thing that I'll mention here that may be of some significance to some folks on the call or owners of companies is that the ProAct creates the right or the possibility for individual liability. Directors and officers can be held individually liable for violations of the Act and personally responsible for those. So the situations where individual liability could be imposed would be where the director or officer directed or committed a violation of the Act, him or herself, where the director or officer established a policy that violates the Act, or whether they are in a situation where they had actual or constructive knowledge of a violation and didn't take action to prevent or to correct that violation. So pretty significant risks that are not part of the labor and employment world right now for individual directors and officers. So I think those are probably the highlights of the changes that would come if this act were to become law.
Thanks, Joe. Circling back to you, Peter. I guess if you're looking into your crystal ball here, what's going to happen with next with the ProAct, and where do you see this going, and what time frame?
Yeah, the ProAct is a declared objective of the Biden administration and the Democratic Party. It's already passed the House of Representatives easily twice. And the last time it passed, this past February, there was not only an across the board Democratic vote, but there were a significant number of Republican representatives that voted for the ProAct as well in the House. Currently in the Senate, as I mentioned before, the ProAct has 44 co-sponsors. And I think it can be reliably estimated that all Democratic senators will vote in favor of the ProAct if it comes to a vote. So the only thing standing in the way of the ProAct passing tomorrow is the possibility of Republican resistance through the filibuster or some other parliamentary means. And we are listening to the news now of the debates over whether, for example, the majority of the Senate will revoke the filibuster rule or change other rules. We know there are behind the scenes negotiations going on to try to pull away a few Republican senators and make them a part of the Democratic legislative agenda. The ProAct is not the only very important piece of legislation that is important to the Democratic Party administration that's at this exact cusp. We also have H.R. 1, the federal election law, which is brand new and which the Democrats really want to pass. And the exact same procedural issue is the only thing standing in the way. So, number one, there is no doubt that the Democratic Party and the administration will continue to try to find any way they can to get this law passed. They've committed to it. They brought it this far. They are very close. It's not going to go away. The second thing is it only takes a minor change in the votes of one or two senators, perhaps slightly more than that, or a change in the Senate procedures for this and other high priority legislation of the administration to pass. Also, remember that I believe was announced yesterday that the former mayor of Boston, he's former as of today, was appointed as the Secretary of Labor for the Biden administration. The former Boston mayor was an executive of the Boston Building and Construction Trades Union for many years. He is a union official who has spent his career building unions up in the Boston area and making sure that unions participate fully in public works such as the Big Dig and that kind of thing. And also we have, as is customarily the case, we now have Democratic appointees to the National Labor Relations Board. So whether or not this particular legislation passes, there is room for administrative adoption of many of these same rules, either directly by the NLRB in decisions or by the Department of Labor in policy, for example, enforcement actions and things. So it would not be correct to say that this act is anything but imminent. Now, how imminent? That's a good question. Right now, the issue depends on whether, because of this and other key Democratic legislation, whether the rules of the Senate will be changed. But even if they aren't, and it's an open question whether they will be or not, even if they aren't changed, there are other ways the administration could take all or a part of the act and try to bring it into being through other changes, or take the act and divide it up into pieces and scatter it into legislation that has bipartisan support and get there by a process as opposed to a single fell swoop. So the one thing we can say, though, is so much has been promised and so much has been made a key objective. The ProAct is not going to go away in the foreseeable future. Every effort is going to be made to pass it.
But it's good to know. I think, this is a wake-up call, I think, for the people on this call, and as well as I just think manufacturers and places with blue-collar workers all over the country, I think they need to understand that the rules of the game are going to change, and that employee relations and a union avoidance strategy, needs to be taken into consideration, because where you thought that it'd be very hard for unions to infiltrate your company, I think as we've heard today, that's what's been keeping them out, it may not be there anymore. So, and there are going to be a lot of unions hungry to try to get a foothold in. So I'd like to try to let people ask some questions, or have a little bit of Q&A if anyone has something to if anyone has any questions, be happy to answer it.
Yeah, guys, feel free to pop into the Q&A side. If you don't mind, I'll sort of open it up just a little bit. Man, this is some fantastic fantastic information. Thank you all so much. I'm excited that we have the information, but I'm scared that we have the information that it's just is what it is, right? We're going to get to figure out how we're going to work through, next steps as manufacturers. But one of the things I just want to get clarification again, Joe, you had mentioned something on the enforcement, individual liability. So directors and officers can personally be held liable if they don't, or if they put into practice things that are not in alignment with union policies. Is that right? Did I hear that right?
Yeah. Well, not with union policies, but that violate the National Labor Relations Act.
Okay.
So yes, that potential would exist. Now, proving that a director or officer personally put something into place would probably be rare. A scenario where I could dream up where that might happen is we're in the midst of an organizing campaign, and a president of a company comes in and says, you guys have been talking to each other about what you make. We don't allow employees to talk to each other about their salaries or about their compensation. And if you do it, you'll be subject to discharge. Well, that's illegal. That type rule is unlawful today.
Right.
And for a director or officer to make some sort of proclamation like that, because he simply doesn't know what the rules are. And then if someone were fired, and I've had some clients who own companies, and they're determined that they can do what they want to do with their company, and so conceivable that type situation could come up.
But today, the company would be liable, not the officer. If this goes through, then the officer could be personally liable for that. That's
exactly right. That's the big change, is that it could flow through, and the corporation or the business itself is not the only responsible entity.
Wow.
Yeah.
Interesting.
And I can tell you what companies are starting to do to prepare for this is to beef up their labor relations departments, their training of the supervisors and managers, and starting, if your handbook and your rules haven't been reviewed lately, now's a good time, because change is going to come, whether it is because of this statute or because of the changes with the National Labor Relations Board.
Okay.
We have different rules under the Obama board than we have now, but there's a very high chance, and I think Peter and Michael would agree with me on this, that we're going to go back to rules that are much more like what we had under the Obama administration.
Right.
And so preparing for that, we're off some of this.
And I think what you're saying is true. I mean, companies and are sort of in a boomerang, sort of mode. I mean, but depending on the administration, you go from
absolutely
one end to the other spectrum, and it's like a yo-yo, and it's it's very hard. But I think people need to understand we're going back to towards very much more employee friendly, union friendly laws and regulations.
So maybe the unexperienced business owner that's concerned about this, now is a great time to be digging in and polishing up on what you can and can't say, and what you can and can't do as it relates to unions. Now would be a good time to get a little education in that space and find who your partners are that would be able to help you if something does pop up, right?
That's right. It's time to remember what the tips are. And some of the folks on the call know what I'm talking about, at least.
Okay.
It's always good to be proactive and not reactive when it comes to this stuff. So
I would say, perfect. All right. Do we have any other questions popping up there? Going once, going twice. Russ, did you have anything else specifically, Russ, that we had to make sure?
Still here.
Okay. Well, guys, go ahead. This is for me. This has been fantastic. I am again thrilled to be able to have great partners like Taylor English come to the table and share information like this that's pertinent to manufacturers, timely, very timely. We don't get into politics. Everybody that's involved with GMA understands that we are not a lobbying organization. We don't get into that space. That's not what we do. That's not what we're going to do. But we want to make sure that we keep folks informed about what's going on so that they can choose to make whatever decisions and have conversations that they want to. But G.I. Joe said, knowing is half the battle, right? At least you know what's going on. Some of the things I had heard about bits and pieces, but this has been a very very helpful in-depth conversation about the things that we need to be looking at. Peter, like you said, it looks like it's going to be coming down the pipe one way or the other. It may be bits and pieces, or it might be the whole thing. And now we're going to kind of see how that impacts. I did have kind of a gee whiz question: is once this goes into effect in 2 years or 4 years, what's the possibility of all that being reversed or repealed? I mean, is that something that we can expect? If the administration changes again dramatically to from one side to the other,
or maybe even if I could add a follow-up to that, considering the current makeup of the Supreme Court and the court system right now, what aspects of the ProAct and these laws you think are the most susceptible to invalidation? If you've thought about that.
Yeah, let me take a stab at it, and then Michael and Joe, I know, will probably want to comment on both of those questions as well. As far as what could happen if there were a change in administration and a change in the House of Representatives and the Senate, from Democratic to Republican, it's conceivable, but remember that this would be a Herculean legislative task to go back again. And right now, it's hard to forecast how there could be such a large change in the composition of not only the administration, but also the legislature. So assuming this will change the next election cycle doesn't have a foundation in fact right now. It's an unknown. The second thing is that I don't think there's anything that is unconstitutional in the ProAct. It certainly is a policy choice that has implications that are different from the policy choices that underlie the National Labor Relations Act at present, which is a kind of balancing between employers and unions intended to be kind of a balancing act. And historically, there's been a bit of a tilt one way or the other as administrations change, but this would be a decisive flip, not a small tilt. But no one has advanced a constitutional argument against this act at the present time. It is all within the ambit of the National Labor Relations Act, which of course is fully approved as constitutional. And so I don't think you have an argument that Congress can't do any of this. The argument that Congress can control labor relations in the country is long since laid to rest.
Yeah.
Joe and Michael may have some observations that may even be different from mine, so they should chime in.
I agree with you about the act. If it passes as legislation and is signed by the president, then it's going to be very tough to reverse it, to change it, to get rid of it. If it doesn't pass, but the NLRB through administrative actions makes changes through case law or through even regulations, then that is much easier to change. And that's what we've seen in the past, from the Obama board to the Trump board to what we believe will happen in any event with the Biden board. It's just that this is Congress attempting to pass a federal law, which is much more solid and much harder to change than the administrative actions.
Okay.
So I think that's the big thing there.
To Russ's specific question, I think we'll get some guidance out of a case the Supreme Court heard yesterday involving the California Agricultural Relations Board and how they come out on the issue of whether or not laws like these constitute an administrative taking of employer property. I'd be curious if things like the rule against employer speeches does hold up under constitutional scrutiny in the long run. But we'll get a clue when this California Agriculture Labor Relations Board case comes out. The last thing I want to add, I know everybody has to step off, is as to Peter's point, I would just add, it would really depend on the particular president's taste for changing the National Labor Relations Act. Not to get political, but Bill Clinton, who was seen as sort of a moderate pro-business Democrat, appointed perhaps the most liberal board in history. George W. Bush just put lackeys and politicos on the board. Swing to Obama, a far left-wing leaning board again, who was engaged in much changes. Trump, for all of his talk, really didn't put a very pro-employer board together. He put Kaplan, a lifetime administrator, on there, and John Ring, a guy who doesn't seem to know much about the National Labor Relations Act, as the chairman. So only Emanuel was a Republican choice that helped the employers. And I think you'd have to wait and see what the employer taste for battle was on the board, because in the last 30 years, we haven't really seen it.
Very cool, guys. That, again, nailed it on that. I really do appreciate that. But in the interest of time, we are going to go ahead and wrap this call up. If you have any other questions, we will make sure that we'll archive this Zoom video as well as the audio. It'll be on Manufacturing News Network. If you're a podcast listener, you can subscribe anywhere that you listen to podcasts, Manufacturing News Network, so you can catch the replay. And feel free to share this information with any other folks in the manufacturing community that you feel would benefit from learning a little bit more about this space. Again, thank you so much, Russ, for your participation, helping us coordinate this, and for the entire panel. Thank you guys so much. It has been another great day at GMA. And with that, guys, we're going to sign off.